commits a felony and shall on conviction therefore before a circuit court be sentenced to imprisonment for life, and notwithstanding provisions of Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole.
Right. Any issue that anyone wishes to raise?
Chair. With regards to prohibited weapon, I note on page 10 that the definition, you have a definition for prohibited firearm, and under prohibited weapon, prohibited firearm is also included. I was a bit concerned when I look at the fact that prohibited weapon has a number of things that quite egregious. Missile launcher, rocket, etc., etc. And if one is caught with these prohibited weapons, they only get 15 years. When minimum 15 years. But why should such egregious like a missile, a rocket launcher, start really at 15 years minimum? I would really recommend that be looked at, Chair.
Repeat that for me.
Yes.
Asking for an increase in the sentence.
For some elements under prohibited weapon, because prohibited firearm is also included under prohibited weapon. I can understand the policy being that it should be 15 years minimum, but I'm questioning with regards to a grenade, a rocket launcher, rocket, missile that can destroy an entire community if it's used. Why should there be a minimum of the starting point should be 15 years for such egregious weapon and of mass destruction?
I think I want to agree with the member, Mr. Chairman. I can't see why we are not able to have a distinction in whether it is for example, a handgun, possibly, to include, you can probably include a rifle to a minimum of 15, but an item such as a grenade or bomb or a missile launcher, like something that can launch a cruise missile. That's what we're talking about?
That should be live.
I think that those should be put in the category of persons getting absolute life imprisonment, so, to be honest with you.
May Minister Chairman, just to put into context how the offenses were actually considered. So in terms of, so there are different offenses under this prohibition section, starting with, in our view, the lowest one being possession simpliciter, for want of a better word. So the offense is really, the sentence is really imprisonment for life, as stated there in subsection 2, subclause 2 of 5. So it says, commission of financial shall on conviction be sentenced to imprisonment for life, and the mandatory minimum being 15 years. So that is the simplest possession, simple possession really of a prohibited weapon. When it goes to stockpiling now, the mandatory minimum is higher, trafficking is higher, and so on. So I think we have to put that into context, but it's still imprisonment for life.
It's important that we just reiterate that the legislation takes a particular view of possession of these types of weapons and regards possession of the prohibited firearm, prohibited weapon, as the foundation on which the other heinous and violent crimes are committed. So at a minimum, the threshold is set high for possession, because if you don't possess it, you can't then use it and wreak the kind of the extent of the damage that can be done, whether they should be treated, punished at the same level of the automatic firearm, the heavy gun machine, or the submachine, all of those which fall within the category of prohibited firearm. So it is a proper question, because not all of the prohibited firearms are on the same level, and they have different capability to wipe out not just an individual, a whole community, could be a whole section of the island, could wipe out the island too.
Possession is the basis for all of the killing, and the view is that the traditional definition of prohibited weapon is not really a challenge, because they have really very, very rarely used. Most of the killing is done by sidearms, 45 and 9 millimeters, and that's what really this is designed to get at. They have added significant numbers of rifles, so they thought that the penalty for possession of such illegal prohibited weapon, well, they were brought on the prohibited weapon schedule, and the penalty will be equal to others, all others, because the others are not a particular risk to the society at this point in time. The risk is really with the sidearms. And therefore, the penalty should be reflected in that.
Chairman, the only thing I would add to what you've said is bear in mind that the sentence that is prescribed is no less than. So it is open to the court, and it is open to the court on the evidence that is before it and on the submission that is before it to go up, because once you fall in this category, you're under penalty for life, unless pardoned.
Chair.
I take Senator Motley.
I would like to know, I assume that there must be some basis on which this mandatory sentencing is being recommended, especially mandatory sentence for possession. It is true that a prohibited weapon is such a wide range, from a handgun, from ammunition to missile launcher, as my colleague said. If you're going to impose a sentence such as this, there must be some data which informs the action. And I believe that as a starting point to this discourse, the data should be shared with the committee. As somebody who practiced in the criminal courts for most of the period that I was in the courts, I am aware of how nuanced cases can be, of how just one piece of information can shift the whole attitude towards a matter. In fact, so cautious am I that when I hear everybody making a big deal about a sentence, I say, I need to know the facts. I don't deal with the reporting of the media when it comes onto a case. My own view is that when somebody is about to commit a crime, they do not think, as you know with murder, domestic violence, and so on, they do not say, oh no, I can't do this. I'm going to go to jail for 25 years. What I understand that impacts them is if they think the circumstances, the sophistication of the police force, the investigative techniques are such that there's certainty that they will be caught. and therefore, and the strength of the prosecution's case will be such that there's certainty of conviction. So I would benefit considerably from your sharing with me the basis, apart from emotion and reaction, to the number of murders that we have by guns. Even if it's 10 out of 10. This is not about the commission of an offense for which most people are not apprehended. I would like it, if the minister rightly points out 8 out of 10, then I have to go to the next point. So how many of them have been charged? And indeed, how many of them have been convicted? I thought my voice was so loud I didn't need a mic. No, I was saying, if we are going to say 8 out of 10 cases, 8 out of 10 murders are committed by the gun, then I have to ask the next relevant question. How many people have been charged with the offense? How many people have been convicted as a result of being put before the court for such an offense? Because whatever we are doing, we have to be driven by information and not emotion. I, like everybody else, am traumatized by the number of murders that we have in this country. And I condemn everyone. But at the same time, as a legislator, I have to bring some balance to this discourse. And I would like, Mr. Richards, that's only because I'm not seeing, is Mr. Henry? I'm not seeing your name. Mr. Bailey. Mr. Bailey, I would like you to tell me what caused this policy position to emerge.
I was just pointing out that we're searching for the statistics that would have informed our policy position. CTD's knows. Now I was saying that we're searching for the statistics that would have informed our policy position in terms of rate of murders that would have included firearms,
I think the statistics centers also we can bring them in terms of number of murders people are charged and.
Member
what I'm saying,
Scott Motley, Chairman, may we just direct her to page 121, because we did set out in the first paragraph of the Memorandum of Objects and Reason that some of the statistic there. Remember, it's just we can't set out everything in detail, but certainly it's an indication of the policy data, and we did anticipate that question about the stats, and that's why. It's put there, but the data is set out year on year, and I think focusing on the last few years, I know.
The data includes the number of people arrested, charged, and convicted?
Yes, we have some information, member, on sentencing as well.
Hold on. We don't, as a general rule, use an arrest record, because you will know the persons who are suspected based on initially intelligence, and then you will have to test the intelligence and convert it into evidence in order to get an arrest. And we have moved, in another place, there is the hue and cry, including from you, understandably and justifiably so, of arresting and charging persons before cases are completed, before we have the evidence that is required to mount the prosecution beyond a reasonable doubt. So if you're asking about the arrest rate, I think that may lead you down a wrong path.
To go down the wrong path, Minister.
You are prepared to go down the wrong path.
I'm seeking information. I'm not defending a position.
Right.
If you give me the information which convinces me, I can be convinced.
No, I understand. I'm not. I have no difficulty with the seeking of the information, Member Scott Motley. I have no difficulty with that.
Member would have to be given
Yes.
complete information in the sense that number of people arrested, number of people involved in multiple murders, because that's what, in terms of clear-up rate, since we have improved our analysis, we are getting you get a higher clear-up rate. Now, not so much because of the number of persons arrested, but you find one person killing 10 people or one gun killing 20 people, that kind of thing. So data, we can derive that from what we have, but the issue in terms of this is that it is on this technical face of it, a grenade and an AK-47 or a M15 or any of the MCU's firearm fitted with a drum magazine would have the service be far more dangerous than a 45. But of the 85% killed by firearms, 90% of them were committed with a sidearm, 9mm or generally. So that, in fact, is the most dangerous weapon out there. The issue of life sentence for, which should have been put here as the principal penalty. Where you really would ask is, and there's accommodation in various sections of the legislation, is for somebody who may come into possession of a 9mm that is not necessarily a shooter. And that is where I think the debate has come up. But there are not many people have been arrested, in fact, very few and far apart, that I'm not aware of anybody who has had to face long sentences from the court because of they were innocent and incidentally. In fact, this separation of the law into two sections came about by the very fact when the original gun court law, and that was not a matter of the government and the power, that's the reality. A gentleman from Mackenzie was charged for illegal possession because his firearm was not licensed. So we have separated the two things. So the unlicensed firearm would not fall in this category. It's strictly an illegal weapon, which is defined as a prohibited weapon. And the illegal weapons on the belly is the cause of the murders. The stories of the occasional person carrying it in their bag to school are very rare, and the law allows for the level for that to be investigated and taken care of in an appropriate way. Number of areas in which the laws may want to express, ultimately the point where the judge may appeal the outcome. But that is the reason for the arms that are caused the biggest problem. And in fact, the policy technocrats were, until the very end, were insisting that prohibited weapons should reflect the severity, the quality of the high-powered weapons. But they are not the cause of the murders, or they are not the perpetrators of murders. Murders is a result of people carrying sidearms. In fact, some of them are even smaller than what I included 22, because the professional killer now kills with a certain level of impunity, but they kill in proximity. We have had in recent times the emergence of contract killing is led to the emergence of a whole class of contract killers, and they use weapons to suit the time. They're going to church to kill. They will carry 22 and shoot them in the back of the head because it is easy to conceal and keep out of sight of everybody and give a look in the eyes and they kill and gone. They very rarely will go for the high-powered weapons. In fact, usually high-powered weapons are used between gang wars, so they shoot up a dance of a rival gang. The killing is done by small arms. I think the question also that you relate is the quality evidence to prove possession. It's a legal question. I agree that the statistics will help to guide that. But in all of this too, we have to, I think, the police operation today is quite different from the police, I'd say, 7 years ago, or let's say, midway when this thing firearms start. Well, it's 20 years. I said in the early years when firearms was just killing people in large numbers, and there's an approach of almost a level of frustration by police officers. We're quite honest in that. Well, I can't get a court conviction, and you do your own literally trial. I think that has changed dramatically, and I think the members can express confidence in the approach of the police in dealing with most of these firearm holders. Is of interest the most recent publication of 88 wanted men. It was done after the evidence was put together. And in the process, so far, of 23 apprehended, only one was shot because it was an obvious shootout. He took on the police in an open gun battle. So I think the issue in terms of proportionality is quite frankly the best solution we can offer. I don't see, and I said we'll give you evidence, but I don't see, I think I understand the use of sidearms as a popular weapon to kill people is really the risk we face. And that's the mischief we're correcting, is the only one.
Minister, we are not debating the use, Use is a different thing. That's not what I am concerned about, because if you catch somebody and they use a weapon, even if they don't hit, if the police apprehend somebody who is firing at them or firing at somebody, there are consequences. But the possession simplicity, sir, the fact of the matter is that there are serious circumstances. One case that came into my office, there 3 people in the back of a taxi. The police stopped the car. The man puts the gun inside of the woman's handbag. If she's not able to mount a defense, if she's not able to get competent representation, she could find herself with a mandatory sentence.
It's unlike I think the law allows for that kind of activity, but I prefer the law in terms of ease of defense. But I'd allow the minister and the technical people to apply.
Sir,
we debated that issue quite extensively, typically where the taxi.
There are many persons in here who practice the criminal law, and all I'm going to do is urge them to reflect on their own experiences as criminal lawyers.
I'm with you. I said this issue was debated extensively. The Chief Justice gave another example, but that was a bad example. He gave an example of a gentleman who had been shot and crippled and kept a firearm for self-defense. But the intelligence confirmed, I was fully aware that the man was still the leader of the gang. So it was a bad weak one. But the relevance of it is still there in terms of someone who may have come into possession of a firearm inadvertently. And I think the law covers for that, but I'd prefer to have Minister may wish to comment before, and we'll certainly bring further evidence to you.
Chairman, I can appreciate the concern that Member Scott Motley has raised. The administration, as you know, in the context of the murder rate and the use of the way the firearm has featured in the high murder rate, and in terms of what is happening on the ground around investigating offenses, atmosphere of intimidation, the difficulty in certain circumstances, many of the circumstances where the firearm is used. The presence of the firearm poses a risk, a high problem for the society and for the administration of justice, for the timely investigation and prosecution of matters, for the availability of witnesses. And it's important to be reminded that a person does not move from charge to conviction just like that, unless perhaps there is a plea of guilty. And even where a plea of guilty is made, it is usually made under advisement. There is process, and there are guaranteed rights and rules in law which deal with the treatment of accused persons. so that the discussion cannot take place in isolation. There is a standard of proof in criminal matters which is beyond reasonable doubt. And while an accused is not entitled to incriminate himself, and while there are rules about competence and compellability, we have to get to the stage where if information is available that will cause reasonable doubt to exist, then that information ought to be presented to the court. Because we can't speak of the issue of injustice in pockets and in isolation. I take absolutely no issue with an ask for the data, because we do agree that the policy must be informed by data. And information that the administration may have in government is a little different from what the opposition has. It's the nature of the insider-outsider status. It's not unique. You know, someone inside of an organization will have more information than someone outside of it. So the view that is taken in respect of firearms, and in particular, what is defined as prohibited firearms and prohibited weapon, is that often by themselves they are viewed in an aggravated way because of the harm that they have done to the society, measurable by the rate of crime, measurable by the cost to the GDP, measurable in so many ways. Not to mention the trauma in the people who are victims, immediate and extended. So unless, so the view that the firearm poses almost an existential threat to the society is one that we may have to ask, are we divided on it? Because, you know, this law is seeking to almost reset the position. And we want to do it so justly, but to make it very clear that given the harm that has been done and continues to be done, there can be no demilitarized zone under view of the firearm.
One last comment. I promise you that I will.
So, sorry, Member Scott, Mr. Bailey, Mr. Richards, I think, has pulled up the data now, right?
I just want to make it clear. I don't want anybody to misunderstand my position. I am not speaking to the use of the firearm. My views are different in that regard. I'm speaking to the possession of the firearm. There's a very real world out there where not a lot of people know that people plant firearm every day on people, that people are forced to carry a firearm because they have no choice, they can't say no, and that there are circumstances that would, if raised, would allow some mitigation in sentence. It's a real world out there. I am not taking a partisan position. I want to make that clear. This is not an opposition position. I have a duty to raise my concerns. At
this point, Mr. Richard, you have some data you wanted to?
Yeah. Yes, Minister. Apologies, I'm going to be reading from a submission which we would have made to Cabinet in relation to this matter, and I might be paraphrasing some of the paragraphs in the interest of time. So one of the things that we pointed out was that pistols and revolvers are the most frequently recovered firearms, as they are preferred by criminals for flexibility, concealability, price, and access to ammunition. Of the total firearms seized for the period 2015 to 2021, more than 80% of them were handguns. And data from the Supreme Court show that the High Court Division of the Gun Court in 2018, illegal possession of firearms and illegal possession of ammunition accounted for the highest share of cases with 782 or approximately 37% and 517 or 25% respectively of the sample. Shooting with intent and assault followed with the next highest incidence. In 2019, illegal possession of firearm and illegal possession of ammunition accounted for the highest share, or roughly 35% and 18% respectively. As with the previous year, which will be 2018, shooting with intent and assault followed with the next highest incidence. Similarly, 2018 to 2019, the data show that illegal possession of firearm and illegal possession of ammunition accounted for the highest share with roughly 34%. And in relation to sentencing, for the two dominant charges entering the High Court Division of the Gun Court, between 2016 and 2020, the average length of sentences handed down for illegal possession of firearm was 6.77 years. The maximum sentence reflected for discharge in the data set was 25 years, while the minimum was 2 years. For the charge of illegal possession, illegal possession of ammunition, the mean length of sentences handed down over the period was 5 years, while the maximum was 25 years and the minimum was 1 year. Granted, this was a sampling of the data that was done. So in relation to the length of sentencing of gun-related charges by plea bargaining, as in the use of plea bargaining, the data show that the average length of sentencing under these circumstances is 3.6 years, with a median of 3 years. The maximum figure recorded in the series is 10 years, with a minimum of less than a year. The sample in relation to the plea bargaining was 114 cases. And I think there's some other data which is, it kind of just outlines the length of sentencing for gun-related cases, and that's how we made it, we put forward a position for attempting to increase length of time for illegal possession.
Thank you, Mr. Richard.
Just to add, Chairman, and to bring Senator Motley to attention to Section 42K of the Criminal Justice Administration Act is a 2015 amendment, part of the 2015 amendment, which remains on the book and is not being amended by this act, where a defendant has been tried and convicted of an offense that is punishable by a prescribed minimum penalty, and the court determines that having regard to the circumstances of the particular case, it would be manifestly excessive and unjust to sentence the defendant to the prescribed minimum penalty for which the offense is punishable, the court shall A, sentence the defendant to the prescribed minimum penalty, and B, issue to the defendant a certificate so as to allow the defendant to seek leave to appeal to a judge of the Court of Appeal against the sentence. A certificate issued to a defendant under subsection 1 shall outline the following: A, that the defendant has been sentenced to the prescribed minimum penalty for the offense; B, that the court decides that, having regard to the circumstances of the particular case, it would be manifestly unjust for the defendant to be sentenced to the prescribed minimum penalty for which the offense is punishable, and stating the reasons therefore, and C, the sentence that the court would have imposed on the defendant had there been no prescribed minimum penalty in relation to the offense. Where a certificate has been issued by the court, pursuant to that subsection, the judge of the Court of Appeal agrees with the decision of the court and determines that there are compelling reasons that would render it manifestly excessive and unjust to sentence the defendant to the prescribed minimum penalty, the judge of the Court of Appeal may impose on the defendant a sentence that is below the prescribed minimum penalty, and B, notwithstanding the provisions of the Parole Act, specify the period, not being less than 2/3 of the sentence imposed by him, which the defendant shall serve before becoming eligible for parole. So the issue was considered, and the harm that you have expressed grave concern about was also considered. And in light of the provisions of Section 42K, the 2015 Criminal Justice Administration Act, the decision was taken that that provision would address the concern in an appropriate case.
Recognize, Senator, is maybe the most contentious clause in the bill and this entire section. It is true, and I know you'd have a number of cases where there are circumstances may suggest otherwise, beside the legal remedy that has been brought to attention by the Minister of Justice. And I think there are a number of other clauses which can be used to buttress that position. But I say in the real and practical world, one of the allegations that was common out there is that an officer could in fact plant a weapon on someone, charge him. And I don't think that charge is now carrying much weight, or the incidence of it, alleged incident, is out there in any significant way. Some may say, of course, that where those cases arise was very rarely that they were innocent. So they're looking at a route out of accumulating. And I'm being non-legal, right? I'm not quoting anything. A way to, in fact, prosecute someone they felt they had enough evidence, intelligence on to prosecute. It is not the police right to do so, and now their privilege. I'm just raised because that is in the real world. That's the fear of a lot of individuals. I think without, going for, I think the culture of the police, especially those particularly in the pursuing the apprehension of the gangs out there and the killers, have certainly changed quite dramatically in the last few years. And there are still challenges, but I think we can rest more confidence that the police will conduct their job in a highly professional way when you get to this kind of activity. There are still challenges, I agree, and I'm not denying that, but I think we are moving in the right direction where that is concerned. And the incidence of alleged individuals who should not be in this situation, but were done so got in there by virtue of scheming designed by and complicity of any member of the security force, I think is way below the incidence of those carrying not even near. Well, even one would be too much. In addition to that, on the other side of the coin, a lot of the killing is now done by, as I said, the shooters, who are not necessarily the possessor of the firearm, especially gang-related killings, where part of the control of gangs is done by individuals who control the cache of arms and release by virtue of the instructions, so that the actual killer themselves, who is easy to, once apprehended and evidence found, everybody will, support the conviction. The person who really manages the situation oftentimes stays somewhat far from the weapon, even if they have control over its possession and control over its storage. So the issue of possession is punishing or deterring people from wanting to possess firearms illegally or prohibited weapons is crucial to dealing with this epidemic of killing out there. That is really the source of the policy-oriented, Senator. I know it's a tricky one. We have to interrogate as much as we can, I'll be honest with you, because I operate in a consensus where this is a real challenge. Let me admit that's the people I represent. But the reality is that we have an epidemic of killing, which even those who are involved are beginning to find, intolerable. And we have to get to a point where the possession becomes a part of the need to possess a firearm is always become reprehensible even to those who are involved in the criminal side, you know. A man who is scamming don't need a firearm to scam. So that'll make it so much that he finds another way, gets on. Not saying he's right in scamming, but if he gets to a point where the one thing he'll do, he's not, because if he scams successfully, he wants to be out of jail to possess his, to enjoy his ill-gotten gains. The man who is transshipping cocaine through any of the vessels going through Jamaican waters, they claim they need illegal firearms to protect their illegal assets, but they really don't have to. Very few can countries take to the station. The possession of the firearm is the source of the homicide referred to by the technical officer, which amounts to, as outlined in the memorandum at the back of the thing, 85% of our killings. And many of them, in fact, look very opportunistic. You know, you find two people and they tell you they're walking on the road, and somebody tell him an offensive word by virtue towards his family. And look, and them kill him because he has a firearm. You know, that's unfortunately has become almost the culture in our large section of our society, and it's not just downtown. I mean, there's a case on trial, I'm calling name, but it's a circle. It was a contract circle. And they employed killers from downtown, or what you make a traditional downtown in lower economic areas, but they all lived uptown. And when they were transporting the weapon and the killer to the destination, it's not the killer who carried the gun. It was the well-established citizen who had the firearm in his waist and happened to have license for a licensed firearm and told the police he has a firearm license, so he have to show him the gun. Fortunately, the police had, as I said, we have certainly the police intelligence and technology are much better shape today. We're aware of what they're looking for and asked for the firearm. So the possession of the firearm is one of the organized killers. But if the police did not have the information and the intelligence that this is the job they're going on, the driver would have been able to say, I have a license, firearm, so my license here, and gone about his business. But he was the one carrying the other personnel to the killing field. And so it is something that I said has, in urging parliamentarians to support this bill, I know we have to look at it in detail and look where there might be gaps and fill them. In fact, I had do almost a SWOT analysis in terms of management personnel to look where there might be gaps that would allow for innocent persons to be incarcerated inadvertently. But I do think from a point of view of the police operational capacity today, based on the intelligence and the whole training and culture of the anti-gang operators and the special squads operating in this area, special ops teams, and the number of people who are involved in this, the likelihood of some innocent bypasser going to jail for life or even having to go to appeal is very low. And I agree it is something that we bear in mind, and as we do it, we must bear it in mind, because even one innocent person going to jail for 15 years is something that nobody wants to carry in the conscience. But the issue of the kind of what has become a popular thing, and in fact, as far back as when we were in school, the ratchet knife and the bucky knife were like signs of a certain maturing at teenage. It was popular to have one of them to show how strong you were and how good you were, and the gangsters would carry them as well. Those are, of course, of no significance now, but like carrying a firearm in a certain community in Jamaica is just a norm. And we somehow have to get this out of the system to the point where, as happened occasionally, somebody will call and tell you, well, instead of buying an illegal firearm, we call the police and inform them that there's some illegal firearms around here. The system of reporting is highly confidential, and we are going to reinforce that position as we proceed. But that is really the sidearms, I said, is the real problem we have. Not the machine pistol, nor the grenades. In fact, I think we have only had one or two use of grenade in the last 5 years in Jamaica. One was in Senton somewhere, and I don't recall where that one was thrown. It didn't explode. Because they're not used to using them, and they might have been old. Machine pistols are used to shoot up between gangs. And Ms. White here from the police, if there are any other incident, Ms. White, that you are aware of, but I think I'm only aware of the use of a grenade in one instance. And fortunately, it didn't explode, right? And I know that I think a grenade launch was seen somewhere, but it wasn't used either. So while those are the most dangerous weapons and must remain in the prohibited list, the ones that are causing the real problems are really the smaller weapons that can be dropped into a handbag or shown in a school bag somewhere. And these are cases where we'll have to examine how they are investigated and prosecuted to avoid the innocent going by. But we have to create an atmosphere based on the statistics where there's a rejection of the firearm as a tool of empowerment by our young men who might be going in the wrong direction.
There is also another area, just to indicate to members Motley and others, that we did give serious consideration to any potential injustice that could be caused, because each case has to be determined on its own circumstances, having regard to, you know, everything. And you will note that there is a consequential amendment to the plea bargaining act. The plea, I just direct members' attention to page 119 of the bill. So you know that in the Plea Negotiation and Agreement Act, the judge is given a discretion in an appropriate case in respect of prescribed minimum penalty and may go outside of the prescribed minimum penalty in an appropriate case. And we are inserting a new provision just ahead of Section 5. We're inserting a new subsection in Section 5 of the Plea Negotiation and Agreement Act. Section 5 provides that a prosecutor and an accused, or where the accused person is represented by an attorney at law, a prosecutor and the attorney at law for the accused, may engage in negotiations at any time before trial for the purpose of reaching an agreement in accordance with subsection 2 for the disposition of any charge against the accused person. An agreement under subsection 1 shall require that A, the accused person undertakes to make a guilty plea to an offense which is disclosed on the allegations on which the charge against the accused person is based, or the facts as agreed, and fulfill the accused person's other obligations, if any, specified in the agreement. And the prosecutor agrees to fulfill the other obligations of the Crown specified in the agreement. And it also indicates that where a prosecutor, other than the Director of Public Prosecution, agrees to withdraw the charge or to allow the accused person to plead to a lesser offense not originally included than that for which the accused person is charged, the prosecutor shall not conclude an agreement unless the prosecutor first obtains a written authorization, whether electronic or other means of the DPP. So that's an administrative and important provision because it does allow for the assessment. But we're inserting that in the case of an offense under Part 2 of the Firearms Prohibition, Restriction and Regulations Act, the part we are now considering, the obligation specified shall include the provision of information that assists the Crown in the prevention, detection, or investigation of, or in proceedings relating to the offense concerned or any other offense. So the policy, the approach of the government, was one of deep consideration on the wider issues that may arise. The position was not arrived at ill-advisedly or hurriedly, but starting with what the data shows about the havoc that is being wreaked on the society, and taking the view that the presence of the firearm, and in particular the prohibited weapons that are not lawfully acquired and registered, so you can't trace them, and just the harm, not only in real economic terms, but in development terms and the trauma to the people, that as of now, there can be no equivocation, certainly where the government is concerned, on the danger posed by the firearm. So we do understand the reality of the society, because our case, we don't exist in a vacuum. And we do hear anecdotally and otherwise concerns, but be reminded that there is due process and there are provisions in appropriate cases that will address the concerns raised. The administration intends to be fair to everyone, but that does not include sending a mixed signal on where we stand in relation to the firearm that is illicitly trafficked and acquired. And if you don't possess it, you can't turn around and use it. And that is why the mere possession of it, against the data that we have and the information, it is viewed in an aggravating way. We haven't stripped the court of a discretion in an appropriate case, even while we say for these statutory offense as a matter of policy, we view it to carry a penalty at a certain level on conviction. But we are very aware that the court has to be able to deal with matters in an appropriate case. But there is no equivocation.
Before I think I saw Member Jackson signaling, but for coming, I'd like to add two things. One is to reinforce, one to add that if the person is not, if the charge is not totally dropped and there's charge a lesser charge, the witness protection program is very efficient, and we are willing to spend the resource to maintain it in these cases, because people may be afraid to talk because they're afraid of their lives. We have taken some steps. We're not perfect, but the process, we have to place some confidence in the process as it is working today. I think it is much better than it was before, and not because of I think the whole society has become sensitive to the issue, and we have been able to make some new efforts in the area that is bearing fruits. And as a country, we have to take some confidence here that the process will in fact eliminate the people easily sent off. I have cases. I must say I have an actual case right now in my possession I'm trying to get expungement for, and the expungement law may have to be amended to allow it to go through, which is I'd say a young man who had just coming literally from overseas. We had gone to work hard, and there was a conflict in the community, and as he stepped in the house, somebody threw a bag at him and said, "Keep this son and don't tell the police." And his case was quite convincing to appear because he was given a very low sentence, but he was sentenced anyway. And now his whole life is a mess. Bright, capable, hardworking young man. So I'm fully aware and sensitive to the issues, Senator, but I think the way the current, I think the law is being made to allow for the requisite escape clauses for those individuals, and at the same time we have to send a clear message to those that we must make possession something that is reprehensible, because I said increasingly the criminals who are organizing have become so structured that they stay far from the trigger. And the trigger man, well, we have to catch them and we have to remove the, what might be termed, pathological killer from society. The organizers are the most dangerous one, and they tend to just the only thing you're going to have is simple possession. In fact, the case I alluded to earlier, the organizer stayed one place, he had his friends somewhere else who had possession. And the apartment, he kept his weapon in another apartment. And these are things that can provide challenges to the courts. But I think we're at a point where for it to work well, all elements of the process, the prosecuting process, from the apprehension by the police officer, the investigating officer, to the DPP's office, and the judges and the defense have to work effectively and well. And we assume they do. All of them are trained professionals. And if they do, I don't think we'll have the kind of undue or the unjust results that I alluded to. And I do believe, as an artist said, there can be no peace, no justice. So if there's injustice in the process, it will not achieve the object, I'm sure. So as I said, I'm willing to interrogate the issue as deeply as I wish, but I think they need to send a very clear signal that the possession of a deadly weapon is what we have to, make reprehensible and get back to a Jamaican society where the gun was just there. It's all become a symbol of empowerment in certain sections of society. The third section, we are serious. We know that some of the instructions and the people give instruction, besides living in high-end apartments, government in prison, we have taken significant steps to monitor those areas, and we will in fact be moving to have established an even more secure venue for them. So we are looking at all assets, but I think we are out of time not to send a very strong signal to society that possession we don't tolerate in any way. You get to a point where even in the difficult, dangerous areas, you'll find a man say, look, don't allow my daughter to get involved in this. Don't put the family. Where they would maybe willingly do today, put that school bag and say, go there. You want to begin to send a signal. It's just intolerable. We're not accepting possession in any way. And they will find other means. Trust me, they'll find other means for those who are involved until we get the society on a stronger footing and a more lawful footing. But we have to deal in a very specific way with the murder rate being conducted by firearms. Minister? I don't know, without right. Oh, Member Jackson.
Yeah, very brief, Chairman.
No, you can't have said it. I share Senator's concern, but I've been convinced. Right?
I just want to, I listen to Minister and yourself, and I want to make it clear. and I don't think anyone else, is asking or suggesting that we should be lenient.
Sorry to interrupt you. I'll allow you to come back. I just one thing that I am in no way thinking either yourself, Member Jackson, or Senator Motley is wanting to express his sympathy for any of these. I say that emphatically. I fully understand none of you or any of your colleagues are interested in any sympathy for these killers. I understand that.
I appreciate
what we're looking at, so you don't have to qualify there.
Okay.
And so I'm saying I don't mind the issue being interrogated because I've faced the problem and I've been through it before and I'll do it again because it is a major shift. And but I think we have to move in that direction. But please proceed.
You haven't said that, and I don't have to reiterate it. You have said it strongly. But the second point, my concern is about that innocent person. That's my major concern. Because in the rush and the eagerness to punish severely and dramatically those who are guilty is the risk of punishing someone who is innocent. That's what bothers me most, Chairman, You see, we hear these cases, especially in other jurisdictions, in ours too. A man is sentenced for 50 years, and after so many years, they find out that he's innocent, and decades of his life is taken away. And we mourn and say, oh, unfortunate. It's easy for us to have sympathy on those persons. It's most difficult for the person, him or herself, and his family, who have to go through that. They were innocent. That is where I'm saying, every single way, not to let anybody off, but in every single way that we can minimize to the most extreme the possibility of that innocent person, then we have an obligation to do that. We can't be that urgent to just throw it at everybody that we allow those persons to go through. And lastly, Chairman, I will ask that on this subject, as we go through the deliberation, we reserve to make a revisit. Because the minister read some things earlier on, which I would like personally to peruse a little bit more, digest, and consult on it some more. So I would just suggest that we put a square bracket around this element and we come back at some other time. But again, you see, when it is, you alluded to a case, and then many other persons can allude to so many other cases like those. And at the end of the day, we as lawmakers, it is what we do or fail to do when we are constructing these legislations that will make us complicit in those injustices. And we have to be careful.
No, we take, and that's why I say, member, that I'm prepared to interrogate the issue in every way. So we look at any loophole that may be left there that could cause a problem for the innocent. But I think the situation justifies strong measures. And I say that at this point I emphasize that the entire process of the work together, from apprehension, investigation, prosecution, trial, and back again to appeal process. There has to be there a due process that allows, for instance, so we can give nothing in life is guaranteed, but we give almost a fair guarantee to the individual who is innocent that they will not end up behind bars for prolonged periods. But there's a large number, and some of the most nefarious characters are the ones who are just in possession. I said the emerging thing is that those who manage the contract killing process, those who manage the gangs, part of their power is to keep possession of the firearm and control of the firearm. So and you can never get them there except by virtue of finding the house or the apartment they own and so forth. So it's a challenge, and I face it in many ways. I think myself and a senator here maybe face this challenge in a very real way more than many here. But we have learned to face it, and we do. Quite frankly, in those difficult areas, there are people who feel they have to do, because the real hardcore killer is not a welcome person in the community. They're not welcome. And they look to us as lawmakers and as administrative leaders of the country to remove them and allow them to live their life and get on with opportunities. But I know it's a challenging one, and that's why I said, so we interrogate it, and if you will leave as is and come back to it again, because there'll be more, we'll bring further data, and maybe ask members of the Ms. White, maybe we'll get some data from the police department to look at again, that you may need some more information to reassure ourselves what we're doing, and you maybe want to look at some of the other incidents in recent times. I said I speak not in defense of the JCF, but I think much change have taken place in this development, and the incidents of the officer acting in becoming the apprehender and the trial and jury and everything is far less reported today than it was at a certain point in time. And if I say so myself, I think we can take a lot of confidence in the emerging professionalism of our police force. There's still problems, and they're dealing with it internally as we emerge quite effectively, I think. But I think we can build a level of confidence in how they operate, they themselves, and not just because of the bodies, the entire operation of the force, especially the special ops teams that focus on this, to collaborate between intelligence, the forensic science department, forensic ballistic science unit is maybe one of the finest in the region today. And of course, followed with investigators and the DPP, whose office now work very closely in these severe cases with the police in getting to prosecution, I think justifies the members of the House expressing a level of confidence in the process that as it's proceeding today as we go forward. And that is, and I emphasize the House, not just government, but the Parliament expressing a level of confidence in the process, from the judiciary through the prosecutorial office through the police departments. But as I said, if we have some more information, we'll pull them together, and we're happy to inform the House. Before I close this, we are 3:10. I was looking really to go to 3:30 today, so we still have some time. Tomorrow morning, I'm going to ask the Minister of Justice to chair the session for a tour period at 10 to 12, and we continue. This section, I anticipate, as I said, will allow for a fair amount of interrogation because it is far-reaching, and is the most far-reaching aspect of the bill. Part 2, because Part 3 is really the fine-tuning of the old bill to take into consideration new requirements and regulation and so forth, and meeting our international obligations. It's not particularly contentious, but it's not that Part 2 is contentious. It has far-reaching implications, and it's taking the law in some new direction, which we must interrogate as we go forward. Minister?
Thank you, Chairman. Since Member Jackson has requested the reservation of the clauses for further consideration, I'll just remind that you would want to look at Section 18 of the Plea Negotiations and Agreement Act and look at the consequential amendment that we're putting into it in respect of what the agreement would have. You want to look on the application of Section 42K of the Criminal Justice Administration Act. That's the 2015 amendments. And I would also invite your attention to the Parole Act, and in particular Section 6, so persons can be reminded how the sentence of life imprisonment is dealt with in respect of parole.
If I can't add to my Minister of Justice, but if I may say another comment is that what I found in somewhat of those intriguing things I've been doing, operating in 2 or 3 joint select committees now, it's not on the way we work here, but for me is a bit of an eye-opener. Oftentimes, I remember in the first one we reviewed, I think then Senator Katie Knight was on. It was amazing the number of things that were told exist in law, but were not being used. So that there is remedy for a lot of things we're trying to, and oftentimes we just come and do things again. And this issue was debated extensively, and I'm saying I'm not in any way restrict debate here, but to get it here, there's some very intense, long debates that the minister could attest to, and really the bill has been in abeyance, 4 years going through the mill before we got to this point. And I think there is remedy in there, enough of that, as well as I said, it will require everyone in the system working when you get these cases quite effectively. For example, the allusion to the Criminal Justice Administration Act, I think section that alluded by the Minister, 42K, is that it's not used very often because it places additional work on the judges, significant additional burden on the judges to do this. So if you can avoid it, you do it, because we know the judges themselves are under stress. But the numbers have increased, and I know the Chief Justice has been working very hard to get his courts to move a bit more, not only quickly, but to ensure that they are done with a certain thoroughness. Not that they were not done that thoroughly before, but the kind of backlog that pulls back people and so forth is not there. We cannot interfere there, but I do think the system is adopting things that are getting into the 21st century, this necessarily digitization and other things. I think you're the director of IT in the course notes, a new appointment, if I recall correctly. So I think all the sections are moving in the right direction, and as Parliament we can have some confidence in it. But certainly we'll do a square bracket and come back to it so we can target even further. But I think it's one that we need to stick with. It's kind of the linchpin of this whole section. right? And we may move on. Minister, go ahead.
Chairman, if we're going up to 330, the other provisions in this part relate to other offences. I believe the same concern would be raised in respect of the sentence. So could we just push on to complete this part in the time to go through those other provisions before we adjourn for today?
Clause 6, stockpiling. No person shall stockpile prohibited weapons. 2, for the purposes of this act, a person in possession of or who causes to be accumulated at any location, A, 3 or more prohibited weapons, or B, 50 rounds or more of ammunition, shall be treated as having stockpiled prohibited weapons. 3, a person who contravenes subsection 1 commits a felony and shall, on conviction, therefore, before a circuit court, be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 20 years that the person shall serve before being eligible for parole.
As I said, Minister, the same question arises, but if you see why stockpiling was put as a separate identity, it suggests in the case of the illegal firearm, when a man when he has 50 or more rounds, he looks at how he's trading in the business. So he may not be actually pulling the trigger, but his contribution requires even extraordinary tougher measures. Because that's the guys who, out of the ill-gotten gains, now buy large volumes, as we have seen the last few weeks, where we have picked up, I think, 3 or 4 packages, and they become traders and suppliers of the linchpins of the underground economy that kills citizens. So he has to get a message. If he goes that far, he will go spend a longer time behind bars.
Very well. 7.
Trafficking in prohibited weapon. 1, no person shall traffic in any prohibited weapon. 2, a person who contravenes subsection 1 commits a felony and shall, on conviction, therefore, before a circuit court, be sentenced to imprisonment for life, and, notwithstanding provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify the term of imprisonment, being a term of not less than 15 years that this person shall serve before being eligible for parole. And just, I made an editorial correction so that the end of the sentence reads consistently with how the provisions are formulated in the other sections.
Senator Sinclair.
Editorial changes will have to be made for consistency, because what the sentencing provision does, it specifies the court, the period, and the provisions in relation to the Parole Act. So those would be consistently provided for in the same way, except for the time frame or the court, depending on what is prescribed.
Jackson.
Just a little clarification here. Trafficking, it arose in, we're going through definition. Clarify or elaborate for me what constitutes trafficking in a functional way, not just in an academic, theoretical definition.
Ask the member to express publicly what he expressed privately on his
tell you, yes.
on trafficking.
I'll give the simple term understanding.
Yes.
It's like there was a case, I think, where a person was picked up with 19 firearms coming from the beach. Well, a beach, 19. And he pleaded that he was functioning as a transport operator for the people who had it, and pleaded guilty. I think he got off a very extremely light sentence when it was intended that he was the one who was organizing and bringing them into to traffic and sell them. He would become a wholesale dealer. And that's the person really trying to lock out of the system, because the numbers are involved and have the resources to acquire these volumes from whether Central America, United States, or Haiti, and bring them to the island. And not many, and they are the real source of the problem, so you have to hit them hard. Oftentimes, some of them have a facade of decency, and that's a real problem. They tend to be otherwise looking on as seen as upstanding citizens, first case with the police, nice gentleman in ABC and the organization and his community and etc. And therefore there's something plausible about what he's doing, or it was inconsistent with his character, and he gets off. When they are the real problem organizers, having invested one. So that's really. But Mr. Richard.
So part of the definition speaks to the movement or the transfer of the firearm or the ammunition, whether within Jamaica or across Jamaica border. So you think of the trafficking.
Let me tell you something that comes to mind that I want to be comfortable in my mind, which is, even following a current trial that is going on now, and you hear about movement of firearm. Simply put, Chairman, John Brown leaves Portmore and go to Kingston. No, I'm telling you, because this thing is real to me, you know. As I speak to you, it is and very painful, I must tell you. Somebody leaves, say, Portmore or anywhere, come to Kingston to collect a gun, to take it from Kingston to there or from wherever to Portmore. He's not necessarily the user of the firearm, but is the transporter, trafficker. While that individual might not be or intended to be the user of the firearm, but he or she goes to collect the firearm and deliver it to someone who is going to commit the act. Now, the gun couldn't fire over there unless it reached over there. So the person who transported it would have significantly been involved in facilitating that shooting or that murder. So when I read the act, I get a sense that, you know, even when I listen to Minister read the thing, it sounds like a more kind of commercial, organized movement. I want to know in my mind the individual who goes to collect the gun and take there knows that not just the possession of the gun, and even if you don't find the person in possession, but there's evidence to confirm that the person did move the gun from A to B, which in effect did the trafficking, the transporting. If such cases would be deemed to be trafficking with the consequential penalties that flow. So help me with that.
The policy should be, I don't know if the law covers it now, but that's what was the intention, because, and we want the sentence to be as severe or even more prime, because that trafficker oftentimes is the one who could be the weak link in the process, because he doesn't want to pull the trigger. He's not buying the gun from us, so he's just providing a certain level of convenience. He doesn't want to go to prison. So if properly interrogated interrogated properly by a professional, you may well get all the information you want. Who sent him, to who he went, and to who he's going to. Who are the implementers of the case that you want to get. So it's important that the case be tried, the event be tried as a different event and be given the severe penalty, but the plea bargaining will allow my way out of this penalty. So I'm with you. And I'm proud, and maybe the 15 years maybe should be 20 as well. Like for.
So, Madam Minister, with all due respect, when I read it, I never pick that up so easy. You know. I want the persons out there.
Yes. To get the message.
To get the message and know that crystal clear. Yes. That don't require any lawyer to interpret that meaning.
I agree with you.
So we have flagged the trafficking for a revision of it with the technical team. But I do get your point, and it is trafficking as contemplated.
Okay.
Yes, but and I also agree with you that we may have to look back on it. And I think also
the tightening of the language,
another reason.
I agree with member.
Yes, I thought you were going to say that it should be consecutive.
That's another element another element.
And direct that one to the DPM for me, please.
No.
Right?
I won't say the minister is leading me, right?
and Member Jackson, I share some of his deep concern from reality of the situation.
Yeah.
right? And
but I think implicit in the clarification I sought, that other question would be answered about the distance travel. Oh.
Williams is
Okay.
very well. No point. So you're asking that the sentence run consecutively, Member Jackson?
I was saying that I would not be indisposed.
I see. All right.
Such
Well,
consideration.
we will take that as a recommendation from the committee.
We'll square back it and discuss it. It's a proposal.
You're getting a sense of who the dove is in this matter. He's asking for square brackets. Next provision.
8, possession of prohibited weapon with intent to traffic. 1, a person who possesses any prohibited weapon with the intent to traffic the prohibited weapon commits a felony. 2, a person who commits an offense under subsection 1 shall on conviction therefore before a circuit court be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. Nine, manufacture of prohibited weapon or possession of device. That should be therefore, not thereof. 1, no person shall manufacture a prohibited weapon. 2, a person who contravenes subsection 1 commits a felony and shall, on conviction therefore, before a circuit court, be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. 3, no person shall possess a digital blueprint or other device for the manufacture of a 3D printed firearm that is a prohibited weapon. 4, a person who contravenes subsection 3 commits a felony and shall on conviction therefore before a circuit court be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 10 years that the person shall serve before being eligible for parole.
The discussion we had earlier on, Donna, regarding the broadening of the beyond the 3D description, would it honor this section we would capture, particularly 9.3, to include other than 3D?
So we will look back on it in conjunction with the definition.
Oh, they will come with
but
something.
What
Okay.
it targets is the possession of the device that would enable you to manufacture it.
Yep.
Okay, fine.
Yeah,
fine.
you could maybe add a sentence to 9.3 which says, or any other means of projecting.
Turning draft
So
or no?
the language could be
DPM?
used by the technical people. That would suggest that if another method of printing a gun comes up, you cover it.
It will
So
be
they just be
concept.
adding to this, not changing it, really.
We'll translate.
Yeah, you'll have to have some concept with the technical team. So, Paul, and technical people always can say, if the metaverse begins to print firearm to make virtual firearm real, or using the virtual firearm to shoot, then we'll have to find a way to cover that. All right?
Clause 10.
Dealing in prohibited weapon. 1, no person shall deal in a prohibited weapon. 2, a person shall be treated as dealing in a prohibited weapon if the person A, buys or sells any prohibited weapon or conducts any brokering in respect of a prohibited weapon, or B, is in possession of 1, 2 or more prohibited weapons, or 2, 20 rounds or more of ammunition. 3, a person who contravenes subsection 1 commits a felony and shall on conviction, therefore, before a circuit court, be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole.
Member Main, then Member
Minister, for consistency, if he's trading in farm, he should be still the same as stockpiling.
I think there is an error in this.
Yeah, it should be the same as stockpiling.
I think that 15
For
should have been 20.
Yeah.
Should have been 20 years. I know the notes reflect that. So this is really an error. Right. Yes.
(11) Prohibition on taking firearms or ammunition in pawn. 1. A person shall not take in pawn from any person any firearm or ammunition. 2. Subsection 1 applies to firearms and ammunition that are prohibited weapons and to firearms and ammunition regulated under Part 4. 3. A person who contravenes subsection 1 commits a felony and shall be liable on conviction, therefore, before a circuit court, to a fine or to imprisonment for a term not exceeding 15 years. 12. Prohibition on diversion. 1. No person in Jamaica and no Jamaican citizen outside of Jamaica shall be involved, whether directly or indirectly, in any activity that results in the movement of any firearms, ammunition, or other category of conventional arms from a person who is authorized under this Act to possess, use, or traffic such firearm, ammunition, or other category of conventional arms, that's the licit market, to a person who is not so authorized to possess, use, or traffic therein, the illicit market. 2, a person who...
Just a little clarify for my... In 12.1, where you mentioned no person in Jamaica and or Jamaican citizen outside of Jamaica, by specifying it here, does it imply, or is you saying that, no man, even I'm more referring specifically to the Jamaican citizen outside, are you implicitly saying that they would, by what they do there from outside, commit an offense in Jamaica? Just asking. Or that would, yeah, just for my own. Can you see you explicitly say it here? A Jamaican citizen outside of Jamaica.
Yes, member, that is exactly what we're saying.
You're making it an offense in Jamaica,
yes,
by that Jamaican outside of Jamaica. Okay.
If I may help you, Minister, I know you support what I think what is seeking to cover. You're aware that especially more in the corporate area than even elsewhere, a lot of the players who are fueling the war are overseas. And I think this is designed to have them, and I don't think it's in there yet, but I'll bring it up now, and my colleague Ms. Wood, that we may have to make this an extraditable offense, because we have a number of people who have been, we have had, is that John the Attendant, we have apprehended quite a few in the United States, but they, although they are charged and they are found guilty and their sentence is much more liberal than we are in this bill. I mean, I think one of the senior operators out of is serving 5 years in New York State, and which means he'll be out in 3 or 4 years. Another is in Florida. I think he got 6, and there are a couple on trial. So it would be good to make them extradite offense, because many of these people have been operating for a long time. It takes a while to get our partners to take an interest in them because of the culture of that country where buying guns is not a big issue. But we're getting more cooperation, and we can make it extraditable. We bring them here.
So, Minister, we have made it an extraditable offense.
Okay.
So we would have made a consequential amendment to the Extradition Act to include these offenses.
All right, so we're on the right track. All right? Continue.
2, a person who contravenes subsection 1 commits a felony and shall be liable upon conviction, therefore, before a circuit court, to a fine or to imprisonment for such term of not less than 15 years, nor more than 25 years as the court considers appropriate. 3, for the avoidance of doubt, subsection 1 applies whether or not the firearms, ammunition, or other category of conventional arms are regulated under Part 4.
To say for those listening, so for this offense, the sentence is one of imprisonment, not life imprisonment, with a range
15 to 25.
depending on the circumstances, which is a little different. Right.
But Chairman,
Yeah.
I don't fathom this here now. We have trafficking that gives you what, 15 years, which I think life imprisonment. No, term of imprisonment being a term of not less than 15 years. That's for trafficking, right?
Yeah, but it's life.
This is more for illegal trading.
Life, but not less than 50.
This is for more for illegal trading.
Sentence for life.
I think this is more for illegal trading, Senator, and I
Yes.
think if they are apprehended in the United States as well or in any other jurisdiction, if it's a life sentence, automatically we have to answer more questions to bring them home.
I see. So
I think that's how
we have
the
made it as
lateral-
far as to
the
be able
system
to-
operates.
It is a fine or to imprisonment. You can be fined.
Eh? No,
This is facilitating a fine.
this is, they know,
25 years.
12.2 says that liable before a circuit court to a fine or to imprisonment, So this person
No one.
who ban?
It only applies to
Then that
Jamaican citizens.
no, the fine, a circuit court, they can't be a fine here. It
Well-
should be illegal trading, but I don't know, you could put you'd have to have a separate clause for it.
if a person is facilitating the movement of, and we are extraditing
Sorry, Richard, I think there's an error here.
extraditing to
Minister,
find them.
Apologies, I believe this would have been an error because the formulation for the penalty provision should reflect what obtains in all the other provisions. So it shouldn't be that you'll be liable to a fine or to a term of imprisonment for such term of not less than 15 years. The formulation here should reflect what you would have seen in all the other provisions.
No, I'm not clear there. You're saying the 12 fine is appropriate here for? I'd expect for illegal trading you could have a different, but diversion.
One moment, Minister, we're confirming because
Yeah.
And just check, we will check to see if this one is a printing error. So we can properly square bracket too,
we'll
because we do
confirm and
have
come
the
back.
notes, and I know some errors came back in the bill,
Yes.
which we had corrected from one iteration to the next. So we'll
It-
just
it'll be
check it.
inconsistent with
But
the
this
rest of
is
the
the
bill.
offense of, this is the prohibition on diversion and what it does to persons. All right?
Sorry, afternoon, Chairman and members. Before we move on, I just wanted to note that I know the MNS technical team and the JCF wish to come back with some kind of reformulation on this particular offense because the wording as it is now, we think can create an intention that was not meant to be. For example, I think the wording as it is now can result in someone, for example, if it's a child, a father leaves a licensed firearm with his son for some reason, that can now result in the offense of diversion. It's not meant to capture those particular circumstances. It's really meant where you're diverting it for a criminal purpose. So just to point out that we want to look back on it to try to formulate it more specifically in that regard.
It has to restructure a bit because they checking the firearm will give the killer, right? So you'll make a note of that. And
13, prohibition on alteration of ballistic signature, conversion of firearm or prohibited weapon. 1, no person shall A, do anything to a firearm which alters the ballistic signature of the firearm, B, convert into a firearm anything which is not a firearm, or C, convert into a prohibited weapon anything which is not a prohibited weapon. 2, a person who contravenes subsection 1 commits a felony and shall, upon conviction therefore before a circuit court, A, be liable to, in the case of a contravention of subsection 1A or B, a fine or imprisonment for such term of not less than 15 years as the court considers appropriate. B, in the case of a contravention of subsection 1C, be sentenced to imprisonment for life, and notwithstanding the provisions of the Parole Act concerning the time within which an offender shall be eligible for parole, upon sentencing a person convicted for a felony under this subsection, the court shall specify a term of imprisonment of not less than 15 years that the person shall serve before being eligible for parole. 14, use or possession of firearm or imitation firearm in certain circumstances. 1, no person shall use or attempt to use a firearm or imitation firearm with intent to commit or to aid the commission of a felony, or to resist or prevent the lawful apprehension or detention of himself or some other person. 2, a person who contravenes subsection 1 commits a felony. 3, a person who, A, at the time of committing, or B, at the time when that person is apprehended for any offense specified in the first schedule, has in that person's possession a firearm or imitation firearm, commits a felony. 4, a person who commits a felony under subsection 2 or 3 shall be liable upon conviction therefore before a circuit court to a fine or to imprisonment for such term of not less than 15 years, no more than 25 years as the court considers appropriate. 5, it shall be a defense to a charge for a felony under subsection 3 for the person charged to show that the person was at the relevant time in possession of the firearm or imitation firearm for a lawful purpose. 6, on the trial for any person for a felony under subsection 2, if the court is not satisfied that the person is guilty of that felony, but is satisfied that the person is guilty of a felony under subsection 3, the court may find the person guilty of the felony under subsection 3. 7, this section applies to prohibited weapons and to firearms and ammunition regulated under Part 4.
In 14.3b, and when we look at what is contained in the first schedule, we have it referring to item 8, any offense under section 45 of the Road Traffic Act. And I think section 45 of the Road Traffic Act is one that deals with somebody driving away offense. You have the actual word in there. I just have my note that says it deals with driving away a motor vehicle. I just wanted to find out if what I found as item 8, it is referring to section 14, and it refers to the first schedule, and item 8 is one that deals with breaching of section 45 of the Road Traffic Act. Let me just...
It's a firearm offense. Exactly.
That you drive away?
Yes.
I think that is a little bit...
We didn't intend to commit a crime.
If you commit a breach of Section 45.
It would be Section 45 of the
Road Traffic Act.
The Road Traffic Act, not the one that was just passed, which hasn't come into force yet, right? So it says every person who takes and drives away any motor vehicle without having either the consent of the owner thereof or other lawful authority shall be given offense and shall be liable. On some conviction to 6 months or $100,000, I think that was changed that was changed, right? Right. So that's the offense.
So if the person has an imitation firearm, sorry, no person shall use or attempt to use a firearm. Okay, all right. So you're saying that they would have used the firearm to take the vehicle?
Yeah, right.
In the process. All right.
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 Members, I'm going to have to leave soon for 4 o'clock. When I do, I'm going to ask the minister chair for me tomorrow morning. Right. We have a 10 o'clock in the morning, but I have a 10 o'clock. The minister will chair for me. And Member Jackson, I've indicated to the minister that, especially that your legal support has gone, Senator, that anything arises that you wish to reopen. Yes, please ensure I will be your commissioner. I'll be collecting for you. Make sure you get a fair day's pay for you.
Possession of firearm or ammunition with intent to injure or cause damage. 1. A person in possession of any firearm or ammunition with intent by that means to injure any person or cause serious damage to property or to enable any other person to injure a person or cause serious damage to property, whether or not any injury to a person or damage to property has been caused, commits a felony. 2. A person who under subsection 1 commits a felony shall be liable upon conviction, therefore, before a circuit court, to imprisonment for such term of not less than 15 years nor more than 25 years, as the court considers appropriate. 3. This section applies to prohibited weapons and to firearms and ammunition regulated under Part 4. 16. Removal, alteration, etc. of a mark. 1. No person shall remove, alter, modify, or in any other manner tamper with any mark referred to in Section 29, whether in relation to a firearm regulated under Part 4 or any other firearm. 2. A person who contravenes subsection 1 commits a felony and shall be liable, A, on summary conviction, therefore, before a parish court, to a fine not exceeding $5 million or to imprisonment for a term not exceeding 5 years, or B, on conviction, therefore, before a circuit court, to a fine or into imprisonment for a term not exceeding 10 years. 17, transfer in violation of United Nations Security Council resolution. 1, no person shall transfer any firearms, ammunition, or other category of conventional arms or any prohibited weapon if such transfer is in violation of any resolution of the United Nations Security Council made under Chapter 7 of the United Nations Charter, in particular in relation to arms embargoes. 2, a person who contravenes subsection 1 commits a felony and shall be liable upon conviction, therefore, before a circuit court to imprisonment for a term not exceeding 20 years. 3, this section applies to acts committed, A, by a person in Jamaica, or B, outside of Jamaica by a Jamaican citizen or a company incorporated in Jamaica. 18.
Before we go on to 18, what is reflected as 15.3? Does that relate to clause 16 or 15? Why am I the alteration of a mark? Isn't that one that it relates to?
16.
Right, but it's under 15. Sorry, not hearing you, CPC.
Sorry. Yes, it relates to 15 because the same 16 already has a similar provision.
Okay.
18, offense of seeking benefit through professing to have or to have access to firearm.
To this one, Member Jackson.
1, a person shall not, in order to gain an unlawful benefit, profess to have or to have access to a firearm. 2, a person who contravenes subsection 1 commits a felony and shall be liable on conviction therefore before A, a parish court to imprisonment for a term not exceeding 5 years, or B, a circuit court to imprisonment for a term not exceeding 15 years. 3, this section applies to prohibited firearms and to firearms regulated under Part 4.
I'm interested that Minister alerted me to this one. A person shall not, in order to gain an unlawful benefit, profess to have.
Minister, I know you're going. I raised this issue before, and I might have to support you on this. That is the idea. We should treat it the same way we treat the others, because what this represents is extortion.
No, but I'm saying to even profess, you say you have a gun.
Yeah.
That, if you're not going to get the material benefit, it drives fear in people.
Yeah, that's what I'm saying.
So even to profess that you have a gun.
No, that's what I'm saying, Minister. This is the source we have debated, and I think we could look at it, because the idea is the man walking to the store and saying, I have a gun, or my friend have the gun. You give me 5,000 a week, or you can't say.
This is intimidation.
It's extortion, intimidation.
And breed fear in people.
It is.
And undermine the quality of their life. You imagine somebody walk around and threatening and professing to have a gun. And especially a person of certain character, right? That by itself is going to undermine the person's quality of life. In fact, I was reading a case in Amsterdam, relating to a Jamaican, and it's a particular point that the prosecution made. I was sharing it with one of my colleagues while I was sitting in Parliament yesterday and reading it. That when you make certain pronouncements that convey insecurity, that by itself is an offense to the state, because it affects everybody. And that general principle is, in my mind, is a very profound principle. And I'm reading it in this situation where somebody professed to have a firearm. So, it is to breed fear in people.
So we need to carry it to the level of circuit court as well.
I don't know which court it called, but it constitutes an offense.
Remember, you raised an issue which is, we have made over that the criminal in the community who is the Don, who controls, often don't carry a firearm. They have control of it some areas. And once they're on, they'll tell you, you know, if you don't operate like I say, what I can do. Now, anybody who behave like that, whether by pretense or reality, is a threat to the stability of the community and should be treated as such.
Mr. Chairman.
Senator.
This particular provision, I think, is one that you can have a lot of mischief created from it.
Yes.
In the same way that you have persons saying,
report them for saying so and so.
Report someone to say that a firearm was pointed at them.
Right.
And the individual is charged and placed before the gun court. And I would take it now, in that scenario, where a person just makes an allegation to say somebody pointed a firearm at me, where you are charged for illegal possession, you're looking at 15 years, right? And this one, that even goes a little further than that, just for a person to say, you know, say, I have a gun down on my hand, so give me money. I think it is a very, although it doesn't carry the type of sentence, it is very dangerous. So when you look, I was reading something that arose in the United States, and they don't seem to even charge persons if there is nothing recovered. No firearm is recovered, there is no evidence that a firearm was used, say, for example, you see damage by virtue of the use of a firearm, or as the case may be. I think that we may be going a little bit too far.
All right,
I think that in respect to what exists now, where persons out of being just mischievous, spiteful, they say, you know, John Bone pointed a firearm at me, and the person faces the threat of serious imprisonment.
Yeah.
Can I
look at
I think what could be done there, take consideration both.
Yeah.
What I said just other time, you would have to indicate in a clause like this that it is for there's more specificity. In other words, the extortionist should be defined, and you have evidence to show that extortionist as opposed to a mischief maker. I think we'd have to.
Chair, I was just going to say something akin to that, which is in a trial matter, in a court matter, we have to look when we draft these things. So the policy, I understand it. I understand what the policy is trying to protect against. But what are the elements that would have to be proven in a court? And what the provision says, person shall not, in order to gain an unlawful benefit, so there has to be an intent to gain a benefit, and the benefit must be unlawful. And then the next element is profess to have or to have access to. So in that phrase, profess to have, what would the Crown be required to prove? That they have said it, that there's a likelihood that they have said it beyond a reasonable doubt being the standard. But how do you prove that? If you said that I profess to have a firearm, and I say I said no such thing, where are we? Is this really an effective provision as drafted? And then my second thing is unlawful benefit as opposed to a lawful benefit? Why are we qualifying benefit?
Extortion is a lawful benefit, so.
It's extortion. What is at the fundament of this? It's extortion we're trying to deal with? Because if we're trying to deal with extortion, then there's language in other legislation we can pull on.
No, the mischief that they seem to correct, as I said, and the police all view that the criminal in the community who is terrorizing the community does so by his presence, not by the use of a firearm. Once he establishes himself, he just has to be there and remind the people that, look, I am the one who controls the power. I was saying, therefore, the clause is relevant, but it's how it is written. We may have to review that so that we know.
Well, as you say that, can I just ask this question before you respond, Mr. Richards? Would that scenario then be dealt with in our anti-gang legislation? Would that be covered there? Because maybe if it is, then that would satisfy the desire.
That's where I was pointing you to, member, because Section 11 of anti-gang actually it's actually the same wording. The only difference is that we've inserted the word firearm. So 11 of anti-gang says, and I think that section was amended with the 2021 amendment, a person shall not, in order to gain an unlawful benefit, profess to be part of or participant in a criminal organization, whether by telling any person that he is a part of or participant in a criminal organization, or otherwise suggesting to any person that he is a part of or participant in a criminal organization. Slightly different, but...
It's not just slightly different, Mr. Richards, with respect. It is vastly different. And it's vastly different because in that scenario, you're talking about a criminal organization. Here we're talking about a firearm where I can come to you and you say I have professed to have a firearm, and I didn't make any such statement or utterance. So a criminal organization, I believe, is different because of how the organization operates in the community. And so I don't have a difficulty with how that's worded in our anti-gang legislation, but I'm having an issue with it here because I do see where it can really be exploited and people can be put before the court and even sentenced in scenarios where no such thing occurred. And it would be very difficult to prove. How do I prove it? But even as counsel, if I'm in court on behalf of the state, how do I prove that somebody has made a statement like this, that someone has professed to have or have access to the firearm? Because the victim, quote unquote, says so. I think we need a little bit more if we're going to.
We're in agreement that the wording needs to be adjusted, because I think I think Member Jackson wanted to answer.
Yes, two quick points, Chairman. One, I'm not talking about convicting anybody on the basis of allegation. It's on the basis of proof. Then, arising from that proof, we know, for example, a lot of threats are being made by voice note now. Right? So if you want evidence, you can get it there to a lot of people. I hear of cases where the telephone calls are the ones which are the main source of intimidation and fear in people. They don't show up before your face, but it takes place, and it's not for extortion. I hear keep on saying applying for extortion. Not extortion, is to breed fear and intimidation in people to commit acts that are illegal.
Mr. Member Jackson, and I use extortion example. Really? No, I'm saying, I'm just using that example, because exactly where you're going in terms of fear. But I'm just saying the wording should be so framed that you don't get into any confusion about the mischief. You'll be the mischief maker. So it will be more, the word to be tightened up to prevent any ambiguity in there. But the principle can be dealt with as a new form of inspiring fear and disrupting community.
Just ask a question. Maybe a little clarification for me, because when we conceive of a provision like this, are we conceiving of, I don't know, the random person that decides to engage in a criminal activity, or really isn't the person we're conceiving of in this provision the gangster or the wannabe gangster?
Well, you can have a one-man operation too. All of it's a criminal individual talking who is extorting and inspiring fear. For example, we go into zones of special operation. You run the gang out of the place, and you run everybody out, including bad man, gangster, maybe not even a gang, but there's some kind of giving problem in the community. He moves out, the community starts to cooperate with the police, things settle down, and you reach a stage you look like you could move. There's no more killing, there's no more, the place is being fixed up, and then, so the community members start get calls. Boy, when I come back, different thing. And that's just the only thing you have on record.
But isn't that the gangster you're talking about, though, is my question? Because what I'm trying to do is profile who you mean.
Yeah, it's a criminal, because he may not necessarily be a member of a gang that you have by definition. But once he is part of the circle of individuals here who are pursuing problems, but the wording of the section needs to be adjusted to ensure that we deal with those people and not just anybody.
And generally, I feel, and which is why the question of the policy rationale would really be helpful for us here as legislators to understand what are we seeking to put into effect in law, because at the end of the day, if I don't understand what the policy is, I don't know what the policy is, and I really don't know whether this provision is effective or not effective, and I'm just operating from what I think ought to be in the context of the laws of Jamaica. So that would be helpful.
No, there is the need for law to prevent the fear inspired by individuals or gangs on a community. When, from time to time, by communication, by inference, they just have to be there. As the Commissioner says, when we speak of, for example, another tool we use, it's not so much to detain and lock up people, it's to remove people from the community who, by their very presence, inspire fear. And there has to be legislation to deal with that. I'm saying maybe as a structure, I do see some weakness in there, we have to adjust it, but there has to be legislation that allows the man who is picking up the telephone from prison or from migrate out to Wattown in St. Ann, which is a quite like a rural area he's from, and he end up calling back to Greenwich Farm or Prairie and say, look, I hear you talk to superintendent and that you are now the leader of the community renaissance, but when I come back, you have to move. basically, and it can be individual otherwise, but so the law should specify and limit it to, in that, as opposed to the one who would just go tell a man, as you tell me I have a gun, and lock him up for mischief. So I think it can be examined. I'm sure the team can look at that.
Sure, Minister, we can look at it because we recognize that really the only difference between the provision as we have it now, as drafted, when you're comparing it to the anti-gang provision, is that in anti-gang it actually provides further clarity as to what exactly constitutes professing. And that is truly the only distinction between the provision. But in terms of the rationale and thinking behind the provision, we want to cover those circumstances where individuals, they are using the threat, the mere threat of the existence of a gun to receive some benefit. So those are the situations we're targeting. That individual may be a part of a gang, or they may not be a part of a gang.
And carry out criminal activity. Because it's not just that they're going to cause give me some money. They will come to the man as they inspire fear in the community. They drive people to the community. The day the police leave the zone, the man have to leave him house, right? So we have to establish a framework in which we can operate without making mischief, right?
Chairman, the provision based on the discussion may need some revisiting. Let us flag it.
So,
all right, so we will note it for revision. We'll just complete clause 19 and then we will take the break.
19, power of minister to declare firearms amnesty. 1, the minister may by order subject to affirmative resolution declare a firearms amnesty if the minister is satisfied that A, the amnesty may result in a reduction in the number of illegally possessed firearms or ammunition in Jamaica, and B, it is in the public interest to declare the amnesty. 2, an order under subsection 1 shall specify A, the period during which persons may apply for the amnesty, and B, the conditions under which the amnesty may be granted. 3, a person who surrenders a firearm or ammunition in compliance with an order made under this section, A, shall not be prosecuted for having been in possession of that firearm or ammunition as the case may be, contrary to this act, and B, may, if the firearm or ammunition is of a type in respect of which a firearms authorization may be granted under this act, apply for the appropriate firearms authorization. 4, where a firearm authorization is granted pursuant to an application under subsection 3, the firearms or ammunition, as the case may be, shall be returned to the applicant. 5, all firearms and ammunition surrendered pursuant to a firearms amnesty under this section shall, except in the case of a firearm returned under subsection 4, be disposed of in such manner as shall be prescribed.
So we will take the break here and resume at 10 sharp with part 3. On behalf of the chairman, I thank everyone.
Madam Minister, before you close, can I just reiterate the request for the data that was discussed earlier today? Can the committee have sight of that, please?
In relation to the age requirement, as well as the sentencing. The sentencing?
Right. I think you were quoting from it as well.
Let's just discuss with the DPM what we extract from the submission that sets out the data and the stats in detail.
Certainly,
and perhaps just provide that sheet. All right, thank you, everyone. The meeting is adjourned.
Before you adjourn again, Minister, and just to confirm.
Will someone move for the adjournment of the meeting?
Minister, before you do, just a quick question in terms of that presentation in relation to the types of firearms. So, do you want that for tomorrow or no? Okay.
No, not for tomorrow.
Okay.
Yes.
Next week.
But we will speak.
Okay.
All right. Thank you, everyone. See you tomorrow. Meeting is adjourned.